Good morning, good afternoon, good evening, and good night. I'm Amanda Ashley. I am here to talk to you about legislative updates. Now, some of you are going to be disappointed because usually it's David Furman. He graciously agreed to let me substitute in. If you don't like that, feel free to tell him. If you do, then definitely I need a vacation and a pay raise, so feel free to tell him that too. Thanks for joining us today. 2025 legislative update on your screen. You should see a little box with the presenter, which is me. If you're not sure who's presenting, we're going to have bigger problems down the road. So you should at least probably know that part. On the right side of the menu is a private chat. You're welcome to send me questions. I will get to as many of them as I can and or that I know the answers to. I'm going to do questions at the end of the webinar, assuming we have enough time. If you're having audio or video issues, there's not a lot I can do about it. So you're going to want to click the no audio or video button, and that is going to send it to our wonderful IT specialist who will help you. And you'll have instructions on the bottom of your PowerPoint screen. You get one CMCA credit certificate automatically generated and emailed to you within 48 hours after the webinar, assuming you attended the whole thing, no cheating. And the credits are not transferable, so you can't give them to your friends. Please save the image of the certificate in the body of the email if you wish to save it. If you wish to preserve it as an image, you'll right-click on it, save it as a photo. And then the reason we have you do that is because the email image is only going to be good for 30 days. So you're going to want to save it or print it, assuming you want it longer than 30 days. As a reminder, if you haven't gotten enough of this presentation today, it will be recorded and added to the Altitude YouTube channel within a couple of days, which means you get to hear the same jokes twice. And then at the end, there will be a survey that pops up at the end of the webinar. We do appreciate any feedback you can provide. Try to do it nicely, though, because I'm very sensitive. Your thoughts and opinions will help us with future webinars. So don't hold back. All right. Are you guys ready? So annual legislative update. I want to say this is our 18th or 19th annual legislative update. And as we are out of the legislative session and the last day for the governor to veto a bill is fast approaching, 30 days after the session. So this is where we are. You'll see those of you who signed up in advance, I have gone through and updated some of the slides as far as the bills that have now been signed since you received this presentation. Okay. We're already having problems here. All right, let me know if you're seeing the slide switch over. Hopefully you are. This, by the way, says, why don't you change the laws, Judge? All right, so our first two that I'm going to talk about are sunset reviews. So some of the legislation, some of the things that are created in our government are, they sunset, so they end. They either have, thank you, Deborah, for responding. So they will either end, repeal, or they can be continued. And so two of the bills that we've seen come around this legislative session are 25-184, which continues the HOA Information and Resource Center. I'm sure you are very surprised. Spoiler alert, we're going to be using this HOA Resource Center for some of our bills later on. So I'll get to that slide. The governor did sign this on May 24th. It was initially scheduled to be repealed. So the HOA Information and Resource Center was going to be appealed September 1st of this year. And it has now been extended to September 1st of 2030. Goodness, talk about the Jetsons. Also, the task force, the towing task force, which was created a couple of years ago, was also set to expire September 1st of this year. Towing remains a hot button issue in Colorado. So we have now extended that to September 1 of 2035. And this is one of the ones that at the time this went out had not been signed. The governor has now signed it as of May 31st. And I like cartoons. I know Alina likes cartoons. Probably everybody else does, so I put them in as well. This says, I'm pretty sure my parents' homeowner's insurance will cover it, as the little boy breaks the window. So one of the things we saw this session was insurance. Insurance remains a big issue in Colorado. Unfortunately, there's not a lot that has forcefully lowered rates or anything like that, or made insurance a little easier to get for the association. But we did see 3 bills come through The first is this 251182. And by the way, if it says HB in front of it, that means that the bill originated in the House of Representatives. If it says SB, the bill originated in the Senate, in the Colorado Senate. So this one was signed by the governor on May 28th, and it's tools to assess risk for purposes of underwriting. So what the heck does that mean? That means that when your insurance company is coming up with the rates that they're charging you and why they're charging you certain amounts, this bill requires that insurer in the state of Colorado to provide information and data on the models they use, as well as the scoring methods that they're going to use for it. And then how those scoring methods and models account for statewide mitigation activities. So for example, if we're looking statewide for, I don't know, fire updates, right? We're trying to impose additional fire mitigation activities. It also requires insurers that use the wildfire or catastrophe models, those are the two big models, to incorporate property-specific mitigation actions or community-level mitigation activities. So for example, if you're in a home where you've done the fire barrier so that you have no shrubs or brush, et cetera, up against the house, then this would require insurers to kind of account for that as far as a mitigation activity, for example. And then, of course, it requires notice from the insurer regarding risk models that they use to underwrite or to provide you with a non-renewal or the price or surcharge. Now, some of you, a lot of you, are getting this renewal notice 2 to 3 days before it's due, and it's 6,000 times what you were paying previously. So this in part is meant to at least explain where those numbers are come from. The insurer, so they have to provide the information, including a description of the model and then the impact of the model on the rates, and then the actuarial justification for the rating factors. So they can't just say, well, this is what it is because our chart says this. They actually have to show why. And then they have to explain how they use that in those decisions. Now, this bill imposed additional notice requirements. So when your insurer provides you with those rates, they actually have to give you notice as to written application as to why the policyholder, so the community, received the rates, the assigned score or classification it did, resulting in the rates that it received. And then the insurer has to provide a list of discounts to policyholders who can demonstrate mitigation actions have been undertaken. And those have to be posted on a public website of the insurer. So it has to have information about premium discounts, incentives or other adjustments that a policyholder may take advantage of that would assist with policy premiums and renewals. And then it also has to speak to what mitigation actions one can undertake specifically for the property or the community level. It also has to list the amount of the discount you would receive or incentive or adjustment associated with each mitigation action. So for example, it would say if you I'm trying to think of one that came through at barbecue grills. Open fires have been one that we've seen a lot this year. So presumably it would include that if you take action to mitigate that and not have those in your community, and then the amount of discount or premium you would receive. And then it has to have a process for appealing the wildlife risk score. If the insurer does not incorporate, so if an insurer does not use specific property level mitigation or community-wide mitigation action in its models, then the insurer is still required to provide the discounts to policyholders who can demonstrate that they did take property-specific mitigation actions, or that the community has taken community-level mitigation actions that are in sufficient proximity, so near enough to the property that it reduces the risk of loss. So with these insurance bills, we're seeing a little bit of movement in hopefully the right direction. We'll see how it actually pans out. But good news, at least we're moving that way. Okay, insurance number 2. So this one is called the FAIR plan, F-A-I-R, and it is HB 25-1205. It was signed by the governor on April 17th. The word on the streets is ultimately this was created to attempt to fill a gap, so to speak, among insurance. So what it does is it's set up to assess and share risk among insurers who are members of the FAIR plan. And it's supposed to kind of distribute expenses, income, and losses. So it is established to provide property insurance coverage, including commercial insurance, when the property cannot, the policyholder, whomever, cannot get property insurance from other companies. So this, while it's not a replacement per se, it's supposed to aid in getting more insurance out there for more places. Member insurers are automatically in and remain members of the FAIR plan as a condition of being insurers in Colorado. Now, you guys know we are seeing a number of insurers who are either leaving or who are threatening to leave just because we're a high-risk state. You know, we have winter storms and hail and flooding and fires, etc. So we'll see with this, like I said, once they're insuring in Colorado, they're part of this FAIR plan, but we'll see how it plays out. We don't know. All new news. Okay, and insurance number 3, copy that, Mr. Burt Reynolds. So this one, 1322, it was signed June 3rd. So it's no longer pending governor signature. And what it does is it adds requirements kind of similar to your inspection of records requirements, right? Where you have to provide that information to owners. What this says is the insurance carrier has to make available a certified copy of your insurance policy to the policyholder upon written request within 30 days of the written request. Now, there's no requirement that the policy be provided to the policyholder any certain way, so they get to choose how they send it, whether it's mail or email, etc. But they do have 30 days to do it and you have to serve it on the registered agent, right? So the insurance company doing business in the state of Colorado, just like any other corporation, is going to have a registered agent, which is listed on file with the Colorado Secretary of State. And that registered agent is the person or company that they have deemed will receive all of their legal notices, etc. So if you're going to make this request to receive a certified copy of your policy, they have to provide it in 30 days as long as you've made that written request directly to the registered agent. If you have done that and they have failed to make it available within 30 days, again, mail, email, doesn't matter, then they can be liable for a penalty of up to $50 a day beginning day 31 from the date that the policy was supposed to be provided. And then, of course, if you were to bring an action against them, this bill also states that they would be responsible for incurring or for the attorney fees and costs incurred if you have to try to enforce that. This isn't, on the one hand, a huge bill, but on the other hand, we have a lot of clients and associations in particular that are waiting to get copies of the policy, primarily if the policy is non-renewing or it's renewing at a significantly higher rate, then this is going to be beneficial. It's not going to get it there immediately. It still will get it there within 30 days, but it at least is beneficial, meaning that you'll get a copy of the policy because there's been some issues with that previously. So now we have landowner immunity. You've seen the past couple of years, we've had different landowner bills coming through. We had one about landowners who post warning signs regarding known risks that will attempt to mitigate their liability. That was in, I think, 2022. It might have been last year. I don't remember off the top of my head. This one, landowner immunity, is 25-1053. The governor actually signed this one back in March. He didn't wait too long on this one. And what it says is that a landowner who is acting in good faith in allowing emergency access to property, so access in connection with emergency, is going to be immune from civil liability for damage or injury to persons or property as a result of allowing the access. Give you an example, the ambulance has to drive across the common elements or somebody's lawn to get to wherever it is that the person in need is located. This bill, if the landowner did that in good faith, would prevent liability of the landowner if someone turned around and sued because it damaged, their lawn or their car or whatever. It does not apply to gross negligence or willful or wanton conduct. So if the landowner goes out and breaks windows in the car themselves and then turns around and tries to blame it on, the firefighter, it's not going to work there. But it is going to work in good faith. Okay. All right. Construction defect. I'll let you read this while I take a sip of my tea. If you can't see that very well, you'll notice that he is holding down the dirt with a strap. which is not going to work when the wind hits. All right, now construction defect. And you guys know I'm not a construction defect attorney, so as a precursor to this, you need to contact your construction defect attorney. But we did see actually 2 bills came through this year, construction defect, one of which passed, which was this one. And this one is referred to as the Colorado American Dream Act, which is interesting. 25-1272, governor signed it on May 12th. So what this does is it creates a construction incentive program for multifamily homes. And it's effective beginning January 1 of this coming year. And what it does is it adds a number of different requirements for construction defect action on both sides of the fence, actually. So not only is there the requirement for a certificate of review, failing to file a certificate of review, but you also can't claim under this program unless there was actual damage, actual loss, actual injury or death, for example. So what this says is that after January 1 of 2026, a builder may participate in the program, it's not required, by providing a warranty that covers any defect or damage at no cost to a homeowner for a minimum period of 1 to 6 years, depending on the component or material. And so under this program, it would say, you know, roofing materials covered for X amount of years, or this type of work covered for X amount of time. The builder, the contractor, would have to have a third-party inspection performed. The third-party inspection meaning a program of inspections of residential housing unit performed over the course of construction. So it's not just coming in and saying, here, we're done, we want you to inspect it now. It's having somebody come in throughout the course of the build to make sure that the contractor is adhering to applicable building codes or construction standards, and if there are any issues or deviations, that they're identified and rectified. So it's trying to catch those issues early on. And then the builder must record a notice of election that they're participating in this program. And the notice has to be recorded in the property records, so clerk and recorder of the county where the property for the project is located. And it has to be recorded before the unit is up for sale. So this is all going to impact a lot of new builds, right? The certificate of review that we're referring to in the slide here, that is the person who is filing the certificate of review has to set forth what the negligence is, the architect or engineer negligence in the defect, and declare in this certificate that that defect can be demonstrated by an individual consultant who has expertise in that same area. You cannot make a claim, again, unless it's actual damage, actual loss, actual injury or death. So no more just we think it's going to. Or if it's unreasonable reduction in performance of the intended function or unreasonable risk of injury or death. There is now a 6-year deadline for a claim under this program. And then there are also affirmative defenses, so 6-year deadline to bring a lawsuit under this for the program claim. It also lists affirmative defenses that the contractor or builder can use if it were to get a claim for these. So for example, if the association or property owner is making a claim and it was a weather issue that caused it or a human caused condition like vandalism, unreasonable failure of the homeowner to timely mitigate the damages, failure to follow maintenance recommendations, homeowner alterations, ordinary wear and tear, abuse, neglect, etc., then those are all affirmative defenses that the contractor can use to dispute your claim. Now, if a claim comes in under this program and has the certificate of review, the construction professional, the contractor or builder or insurer, can go back to you if you're the claimant and send via certified mail or have it served on you an offer to settle by either saying we're going to remedy whatever the defect is or we're going to pay for the remedy or defect. Or they can give you a written response basically identifying standards and explaining why the defect is not actually needing repair, isn't why it's a defect. Maybe it has an affirmative defense that they're going to bring up, or it's outside the work of the construction professional. There are also additional deadlines on here imposed under this bill, regarding reporting the scope of the inspection. The offer has to be provided. This offer under number 1 there, the first bullet point, has to be provided within 90 days after the deadline to inspect the property, or written response within 30 days after the deadline. And the total time for the insurer or construction professional to provide the information is 120 days from the date the claim comes in. It's a lot of stuff, okay? Which hopefully we'll never need, but quite frankly, things happen. So I would get with your construction defect attorneys or call your attorney and start talking about it. Now, are we ready for the big one? I say big one because this is the one we get the calls about. Collection and foreclosure bills. Yes, there is a new bill this year. Yes, you were required to update your collection policy by law in order to collect your delinquencies. I'm really sorry. I have nothing to do with that. I promise you I'm not telling them to do it just to run up legal fees. This is something we're seeing. As an FYI, this is now what, the 3rd year we're seeing just collection coming through. So it would behoove you as a board and a manager to build these things into your budget, because this isn't going to be at the end. We're going to see these every year for the foreseeable future. Bills that affect HOAs. There was another bill this year that we thought was going to pass that was alternative dispute resolution that would have required updated policies. So you're going to have to budget for them, or you can call your legislator, or you can do both. All right, so this one. Okay, you ready? So 25-1043, which has now been signed. So as of 6/2, it was pending governor's signature. It was signed yesterday by the governor, and it amends a whole bunch of things in Kiowa. It amends the lien provisions, it amends the collection provisions, it amends some other stuff, and it also requires the HOA Information and Resource Center, which is perhaps why it was not sunsetted this year, to track inquiries, complaints, and other information. And it requires the association be in strict compliance. And what does that mean? It means that when the association is bringing an action, let's say for foreclosure under its lien, that it has to comply. It no longer has wiggle room to say, well, we missed this and it was a harmless error, or we didn't do this and it was a harmless error. The association now has to follow the letter of the law, so to speak. Okay. The letter of the law and the association's governing documents, to the extent they don't conflict with the law. Now, under this bill, foreclosure, if you're starting a foreclosure and we get through the foreclosure process on behalf of the association, the homeowner, well, let me back up. Firstly, if the association is found to not have strictly complied with one part of the law or its governing documents, the court may place the proceeding on hold to allow the association to come into strict compliance. However, during that time, when you're trying to come into strict compliance in order to proceed, you cannot assess or accrue late fees, interest, or other delinquency charges. You also cannot have duplicative or inflated attorney fees due to the stay in the court proceedings to allow you to come into strict compliance. What does that mean to you, really? It means that when your attorneys tell you, hey, you should probably do all of this stuff, and we recommend you be more prudent and send out these additional notices, even though you said you already did, it's to keep you from having to spend a lot of legal fees down the road while the foreclosure is stayed and you're not getting any money, so that you can go back and do those things. Okay, so if Kate from our office tells you to resend them, because that's what she's trying to do, is protect you. Same with the attorneys you're working with. More, notice the font is smaller because I had to type more in here. Okay, so the association, so remember that the association previously under these collection bills had to notify owners via certified mail, the payment plan offer letter, right? And via 2 other means, either telephone, text, or email to the owner. And a lot of the associations came back and said, well, we don't have that information. And then the attorney's office said, well, so the statute as it's currently written does not say, okay, you don't have to. It says you have to, regardless of whether you have the information. So then you end up looking for information and doing skip traces, etc. So this bill While that requirement is still in place under this bill, that you notify the owner via 2 additional ways, email, text, or phone call, in addition to that certified letter. This bill says that you can send an additional notice to the owner, that payment plan notice, via registered mail if you don't have the telephone and email address. This does not replace the certified mail requirement. It just gives you an additional avenue if you don't have the information. However, this bill also imposes the responsibility on the association to periodically request telephone and email information from its owners to use for contact. It does not define periodically. So probably once a year, maybe twice a year. I don't know. I don't know what a court's going to say. Periodically to me is probably as part of your, let's say, annual disclosures, you request it. But I could be wrong because there's nothing in the statute that says what the time frame means for periodically. So you still have to request it. Homeowners still don't have to provide it. But if they choose not to provide it and you don't have it, you now have the option to send that additional notice via regular mail. Okay? First class mail. You can't send it via like magazine mail. All right. The other thing is previously you had to, and did I say regular mail, guys? Not registered mail. So the first, you're still required to send it certified mail, but then you have the option of sending it regular mail. So I don't know if I confused my words on that. If I did, I apologize. All right. You still have the requirement to give the owner ledgers, right? Previously, it said that you have to provide information for the owner to be able to contact you to obtain a ledger, and that the letter had to have a breakdown of how the balance was accrued. This bill now says that you have 7 business days after the owner requests the ledger to provide it. Some of you aren't going to like that. Most of you aren't, because it's hard, right? You're busy. You have tons of ledgers. If you're a self-ran board, you're creating them yourselves. It doesn't matter. You have 7 business days to provide it to the owner after they request it. And there's no requirement that the owner requested a certain way. So the owner can call, they can email, they could send a pigeon with a little note on it. It doesn't matter. You have to provide the ledger in 7 days. Okay. Additional notice information in your requirements. So not only are you going to have to redo your collection policy, but when it comes to these notices that you send out, your delinquency notices and your notices about foreclosing, it has updates. So you have to include that if you are going to sell the unit at a foreclosure sale because of the delinquent assessments, that can result in the loss of some or all of the equity of the unit or lot. When we say unit, we use unit, lot, dwelling, all interchangeably right now. So the homeowner can lose all their equity or some of it. In your notice, you have to also include availability of and instructions on how to access free online credit counseling information through the HOA Information Center. So the online information, the information is related to collection of association assessments, including the association ability to foreclose and force the sale of the home, the availability of online information from the Federal Department of Housing and Urban Development, and there's a link regarding the credit counseling before foreclosure that is located on the Department of Local Affairs website. So you will have to have those in your notices. Great news. It's not great news. I know some of you hate this. Don't shoot the messenger. All right. Now, let's say you get to the time where you're ready to foreclose. You have to send specific notice requirements 30 days before initiating that legal action to foreclose. You have to send it via in writing, so mail and electronically, email to the owner that they can participate in credit counseling. It's available through the HOA Information Center, and the credit counseling may include additional discussion items. This is different than the notice I just talked about. So you're actually doing this twice. This notice specific to the foreclosure must be sent to the owner, designated contact via certified mail, and at least 2 other ways as well. And the notice must contain additional information regarding the intention to file a lawsuit, sale of unit, loss of equity, right to participate in mediation. Okay? Lots of notices. So the notice on slide 15 is your general, like your delinquency notices that go out. And then this notice on slide 16 is specific to foreclosure. Now, keep in mind that the credit counseling is going to have discussion of amounts owed in unpaid assessments, related costs, the impact of a foreclosure on the person's credit, that additional debt may be incurred if the foreclosure sale goes through and is completed, options for the owner to remain in the property or remain owner of the property, and other options that may be available to an owner to avoid foreclosure. Prior to sending this notice, you also must request the owner's telephone and email address if you haven't already. Now, all of us know that you will have done that already because you periodically request it as is required in the first part of the bill. Okay, the HOA Information Resource Center is the same when they set the task force up. For example, last year it went through the Information Resource Center. They provide classes, they track registration, they have a whole bunch of things that you can access on their website, and now they even have more responsibility to a certain extent. So it's like a service. Okay, more notice requirements, guys. So slide 17, more notice. The notice, so that foreclosure notice must again include participation in credit counseling, how to access the free information through the Resource Center, because if you go online to the HOA Resource Center in Colorado, then it has links to various things, including how to submit a complaint against your HOA. This bill does not apply to timeshares, and it further requires that when you're foreclosing, your attorney let all of the other lien holders know within 5 business days of initiating the foreclosure. A lot of attorneys are doing that already. What that means is when you're foreclosing as the association, you're going to notify, for example, if there's mortgages on the property, if there's the owner was sued and there's a judgment lien against the property, you're going to notify all of those lien holders. And then the big one that comes out of this slide here is that when the foreclosure is pending, the owner can file a motion to stay the sale of the unit, so of the property, during the foreclosure. So previously, if an owner filed bankruptcy, it would put an automatic hold on the proceeding. But in this case, the owner doesn't have to file bankruptcy. They can request that the court put a hold on the foreclosure for up to 9 months to allow them time to sell the property and avoid the foreclosure, basically. It's 9 months initially, and then the court can continue extending that for good cause. Now, in this motion that the owner has to give to the court, if they give it to the court, it has to contain the fair market value of the unit. So it has to show by appraisal or market analysis how much the property is worth and how it was assessed, or if the owner believes it is perhaps less than fair market value, then they would bring in an alternative valuation. And the court's going to look at all of that, but then, like I said, we'll stay it up to 9 months initially, which means that you all are going to be in a holding pattern for 9 months while the owner attempts to sell their property. And then, like I said, the owner can come in for good cause. So let's say the owner says, the property's up for sale, but we're not going to close for another 60 days. The court would likely find that to be good cause and extend it another few months for them. Okay, this is the last slide on collection and foreclosure. So as part of this bill, okay, so we have the collection policy with the new notice requirements. We have the foreclosure new notice requirements and procedure, or additional notice requirements and procedure. And now the other component of this bill is there's registration requirements. And that means the association, as part of its annual registration with DORA, has to submit the following information. Okay, so when the association registers, what is it, usually January, the association now, in addition to its annual registration, has to include how many owners were 6 or more months delinquent in either current or special assessments, how many owners the association sued and obtained a judgment against, how many payment plans were entered into, so not how many were offered, but how many were actually entered into by the owners, how many foreclosure actions were filed, and then if there's any other information that DORA were to request regarding collection and foreclosure, you would comply with that. This means that you're going to have to work with your attorney's office to get this information done, right? Because some of this information, like the 6 or more months delinquent or the number of payment plans entered into, that's going to be things that you as a self-managed board or you as the management company have access to. But then you're going to have all the ones that maybe the attorney office has, like how many judgments were entered into or whether the foreclosure was actually filed. So it's going to require everybody to work together. We're not going to sing Kumbaya while we do it, at least not that I know of, but we're going to all have to work together to get this done and in. So get your boards on board, okay? All right. Vehicle immobilization. I'm going to keep going. I promise I'll get back to your questions. Much like we've seen towing rules and regulations, an uptick in towing rules and regulations, those of you who said, you know what, we're going to do booting instead because it's not as heavily regulated as towing, Debbie Downer for you, it is now going to be. So this bill, which was signed June 3rd, it mostly, much like the towing bill, mostly applied to towing companies. This mostly applies to vehicle immobilization companies. So when we're talking about vehicle immobilization, we're talking about the booting, which is the picture on the top there, or those, they're like these crab things that go over the windshield. That potentially would be vehicle immobilization. So what this does is it mostly applies to those companies as far as the procedure and process and requirements and registration requirements they have to go through. However, great news, it also applies to property owners like HOAs and common elements. And what it does is there's a lot of requirements that you saw in the towing bill, two towing bills, 2022 and 2024, that are now you're going to see in this booting bill as well. So it's going to impose similar requirements such as providing written parking rules to owners when they enter or vehicle operators when they enter the property. You have to give 24 hours notice prior to immobilizing the vehicle, place the notice on the windshield. You have to do the documented permission form, just like you do with towing now, where you have to sign that form no longer than 24 hours before the tow. That would be applicable here as well. I'm sure you're all super excited about this. All right, this one, I had it in an honorable mention category at first, but I bumped it up because I got some questions about it. So previously, you all would have people come out to check your backflow devices, all your water devices, sprinkler, backflow. And then a bill passed that said they had to be licensed to do that, those inspections. And so this bill now comes along and says, well, we changed our minds again. And so what it says is that those individuals who are inspecting, testing, or repairing backflow prevention devices are exempt from licensure. So they don't have to have the license to come in and do those three things. But if you have somebody coming in who's installing or removing the backflow prevention device, that person has to be licensed. Additionally, with that licensure, so licensed plumber that's installing that backflow, they have to affix a tag to the backflow prevention device stating what the service date was, what their registration number is, what service was performed, etc. Okay, so some of you are going to be happy about this one because we were just talking about it a few months ago as to whether or not licensure was required. Others of you don't care, and that's perfectly fine. All right, honorable mentions. We had a couple, and if you actually go to Altitude's website, there's a few others on there that are peripherally affecting HOAs, but not really directly impacting. But these two I went ahead and put on here. So the first is accessibility standards as stringent as international building codes. What the heck does that mean? It means for new builds. So if you're going in, if you're one of those people who is working with new developments in particular, this now states that their accessibility standards that they adopt have to meet or exceed the international codes. So it's going to up that a little bit and make it a little more stringent. And then the other one, 25.11.13, that one was signed May 20th. It goes into effect January 1st. And what it says is that the local entities, so the government, shall not install or plant or allow any person to install or plant non-functional turf, non-functional artificial turf, or invasive plant species as part of a new or redevelopment project on any portion of applicable property within that entity's jurisdiction. So the city can prevent you, the association, in new builds or redevelopments from putting down artificial turf, for example. The difference with this bill is previously it did not apply to residential property, and now it does. And it specifically applies to common interest community property. Further, on January 1 of 2028, the local entities, so municipalities, counties, etc., shall enact or amend their ordinances, resolutions, or other guidelines, regulations, and laws regarding the new development or redevelopment projects to specifically state that they are regulating the installation of turf in order to reduce water demand. That also applies to applicable residential real property, including the community association, common interest community property, so the association property. So if you are decided you're going to turn your tennis courts into a football field, this is going to affect you. If you're not, then you're probably not going to have a lot of information or a lot of issue with this unless you're a new build. However, this bill does not restrict somebody from installing grass seed, native sod, or seed that has been either hybridized for water conditions or low water grass. So as long as the native sod or the grass seed is hybridized or low water, then you can still do it. Okay, so no football fields. All right, now I'm going to attempt to go through your questions and we'll see how we go. Are communities built in 1987 exempt from all of these? No, not necessarily. So Kiowa sets forth which ones are going to be applicable to pre-Kiowa communities, and you're going to find that a lot of these are still going to apply. Can you have a process server post notice on the door of the property? You can. So some of our associations still like that leftover requirement from, what was it, 2022 when we had the posting. So what I would do is, first of all, you're going to want it in your collection policy to notify owners that that's what you're going to do. But the caveat is, because there was always a question of whether or not you could recoup that cost against the owner anyway for that posting. But now, because it's not even a requirement under the law to post it, you may not be able to recover that money. But there's nothing prohibiting you from doing it. And some of our associations and management companies still do it. They love doing it. They said it gets more response, so they've continued to do it. Other associations and management companies either A, stopped doing it because they felt like they were taking their life in their hands when they approached somebody's door, or B, felt it was more scarlet letterish, so they're not doing it anymore. But you can. Altitude, yeah, we'll draft letters if you want. You would just reach out to your attorney. Okay, let me go back. If the association currently has non-functional tennis courts and wants to repurpose those, is that no longer allowed? No, it's allowed to repurpose. What isn't allowed is you're going to have to be careful about what kind of turf you install, and our non-artificial turf, etc. So you're going to want to do like low water grass, xeriscaping, etc. Now, if you're repurposing the tennis court into a pickleball court, then this law isn't going to affect you because you're not going to have turf, at least as far as I know, on the pickleball court. Although, as an aside, when pickleball originated in like 1973, it was on an old tennis court that was made of dirt and low-level grass. Why do I know that? Because I wrote an article one time. Registration with DORA. I don't know how DORA is going to handle it. If it's going to have forms, but I don't know if they're going to send it out as part of their annual registration or if it's going to be separate. Your parking and towing policy. If you have booting in your towing policy, then you're going to need to amend it to comply with these new regulations regarding vehicle immobilization. If you don't and you only have the towing policy, then there were no changes to towing this year, only vehicle immobilization. So you need to take a look at your policy and see if it has that information. All right, let's see, I'm going down. Does the statute require admitted carriers to participate in the FAIR program? It says that all carriers that are conducting, insurance carriers that are conducting business in the state of Colorado are members of that program. All right, going through. It doesn't specifically call out maintenance turf in HB 2513. What it states is specific to, what did I call it here? Let me find my sheet. It's specific to artificial turf, non-artificial turf, and what's the other thing that I said? Do you guys remember? Making me look up my documents here. It's getting real. Invasive plant species. Yeah, towing is the worst. So towing, the task force on towing, the question is, was towing extended till 9/1 of 2035? And it's the task force that was extended. All right, effective dates. 1043 retroactive to foreclosure actions already filed. 1043 is effective October 1. Good news, right? Because the last couple of years we've seen it effective like first week of August. So got a little wiggle room there. I would still encourage you to get in with your attorney right away if you're having them draft the policies, because you know everybody needs one, so there's going to be a backlog. But it is effective on, what did I say, October 1st. 1182. I'll have to look that up for you because I don't have it right in front of me, and I apologize for that. I thought I did. And no, it's not retroactive. So we're going to probably want to do the same thing we have done in past years, right? So if you have things that are ready to turn over to your attorneys now under the current law and your current policy, which should be your 2024 policy, and don't give me that look because I know some of you still haven't updated that. But those you're going to want to turn over. And then as of October 1st, if you have one that you're ready to turn over, but you didn't follow the new laws under 1043, it's going to be bounced back to you to make sure you follow those requirements. Okay, let's see what else. Parking in fire lanes. No, it doesn't change it. You're still not allowed to park in fire lanes. What it changes is just that the notice requirements under booting. With all this collection requirements around foreclosure, do we offer a collection approach that would involve garnishments? Yeah, so most of your attorneys, including Altitude, would offer just general collections prior to foreclosure. And when you foreclose, you're required to try to obtain a judgment anyway. I should say, and Kate's going to correct me on this because I think she's on here, you're required to get a judgment. I do believe there's few exceptions, but at any rate, so presumably you would have gone through that, right? Like many times you want to use foreclosure as a last resort because it's expensive, it's taking away someone's home, it's lengthy, it can be incredibly lengthy if it's disputed. So you'll want to talk to your foreclosure attorney about that. But as far as the garnishments and collection approach, once you have a judgment, garnishment is an option. So you want to talk to your collection attorney about that. Is the only way to enforce parking in single-family associations to do so via towing or to eventually tow as opposed to fining? No. So you can tow, and if you tow or boot, you would have to follow those requirements. But if you have, now this is again assuming you own the streets. If they're public streets, you can't do anything. You have to call the city or the county. But if you own the streets, then you have a couple options. You can tow. You have to give the right notice, or you can follow your covenant enforcement policy and fine. Now, what's the problem with that? Well, the problem is that if somebody is simply parked, like say they're parked in guest parking and they shouldn't be because your parking rules say they can only park in owner parking. You have to, under your covenant enforcement policy, give them that initial notice. Some of you may even have a warning letter, but the initial notice that requires that you give them 30 days to cure the violation. And then in addition, before you fine, and then you can do an additional 30 days before you turn it over. So what happens? If that vehicle moves at any point within that 30 days, then they've cured the default. So if I drive out and then I drive back 2 days later and park in the same spot, it's a new violation. So that's a different issue. And we haven't seen any movement on enforcement with regard to that type of things. Okay. Is a homeowner delinquent if they're paying on time under a collection plan? So I've seen two approaches to this. I mean, technically they're still delinquent because they still have a delinquent balance, but I have seen associations that say if you are current in a payment plan and you're also current on your monthly assessments as part of that payment plan, then we're going to treat you as if you're remaining current, even though that balance is still outstanding. So you're going to want to look to your governing documents on that. If there's nothing in those, you're going to want to call your attorney and see what they think. All right. Some of you are going to sing if they provide timely info. I agree. The payment plan, what the statute says with regard to that payment plan is it's payment plans offered through the HOA. Does this new collection law apply to any pending foreclosure? I think I answered that one previously. So no, as depending on where you're at in the foreclosure process. If you're early on and you still haven't gotten to the foreclosure by October 1, then yes. If on the other hand, you're at the date of the sale right now and the sale is in July, then the owner is not supposed to be allowed to request the stay. Whether we have a court that'll disagree with me, it's entirely possible. Collection policies, they got to be updated again. I know I said that before, but I'm saying it again. And that was one of the questions. Let's see, we talked about that one. As a result of the changes and requirements for collections, at what point can this be turned over to the attorney? Should we start with the first notice, 30 days, 60 days, etc.? It's going to depend on where you're at in the process. So if you are in the process right now under your collection policy where you have given them that payment plan letter and that's the last thing you need to do and wait the 30 days, then you can turn it over now. Under the new collection law, once October 1st hits, it's going to be the same thing. You're going to follow your updated collection policy. And then when you get to that final notice in your policy, where it's usually your 18-month payment plan letter, you wait the 30 days. If the owner hasn't responded, hasn't paid off the delinquent balance, and or hasn't entered into a payment plan, then you would turn it over to the attorney after the board votes in executive session and signs that resolution or records it in the meeting minutes. All right, so here was a question about the registration of telephone and email. The question is, do we have to periodically request it per homeowner, or can a general email to all owners requesting the contact information suffice? There's nothing in the statute that says it has to go either way. It just says periodically request from owners. So in my mind, that means that you could send out your general information with part of, let's say, your disclosures, and then an email that says, hey, we need your updated information. Now, keep in mind, if you're sending it via email and you don't have emails for certain owners, they're not going to get it, right? So you don't want to send it out just via email. Likewise, if you're requesting updated information and you're sending it to an old email address, they're never going to get it. So you're going to want to send it some way other than email. You can certainly still send it via email and say, hey, owners, it's time to update. But the issue you're going to run into there is that if it's an old email address or those you don't have email addresses on, you're going to have a problem. So you're going to want to do a little more than that. How many foreclosures are happening with HOAs in the state of Colorado? This person's been an HOA manager for a number of years and have never had an HOA do a foreclosure. They're relatively low. They're certainly, and I don't have the number in front of me, although I did recently. I don't remember off the top of my head, but they are significantly lower than foreclosures by like the mortgage companies, for example. One of the problems is that a lot of associations held off during COVID from foreclosing, even though they were already kind of going through that process. And so then once COVID passed and everything kind of kicked up again, some of those foreclosures that have been held were all filed. And so it gave the illusion that a number of foreclosures were happening all at once, and that must be the number every year that people are doing. Like everybody's foreclosing, and they're foreclosing on, $500 assessments. And that's not actually the case. If you work in the industry or you're familiar with the industry, you know that oftentimes foreclosure is the last resort, that when you do foreclose, usually like the mortgage is going to come in because they don't want to let you foreclose anyway, or if you do foreclose and end up owning the property, you're taking it subject to the mortgage. It's not like you just get it free and clear, so on and so forth. That's information you'd have to talk about with your foreclosure attorney. However, it gave the illusion, these numbers, that foreclosure was a much larger problem than it is. And then of course we've had all kinds of news articles about various foreclosures happening. The numbers are actually pretty low. So one of the good things, I think, about this door registration requirement that you report how many foreclosures have been filed in the last year is that it's going to show significantly less foreclosures than what everybody thinks. As to why the all over regulation, that's a good question. So keep in mind that a lot of these bills are proposed by people that don't work full-time in the industry, if at all. And so sometimes when we propose bills, it's like if I proposed a bill that I think is a good idea about, family law, I don't do a lot of family law, So it might look like a good idea, but I'm not intimately familiar with family law, so it might not actually come across the way I wanted to or intended to, or maybe I just don't have that other information. And so that's a lot of what we see now. Is we see most of this legislation is being pushed by a small group of representatives and senators, and then they have their stakeholders. So the people who are either struggling in their HOAs or who are anti-HOA, et cetera. And then, of course, the other side has their groups who tend to be more pro-HOA, or maybe they're not pro-HOA, but they're saying, hey, this isn't as big of an issue. And so then what happens is it's debated and you try to work together, and here comes the regulation. As to why this is the focus, I don't know right now. I don't know why HOAs are in the focus. They just are. But I don't know how long they will be either. So we'll see what happens. All right, let's see. I think we talked about these. I'm going to go back up to the top. We're at 12:55. To confirm, for collection letters, one certified and the other two methods registered mail and email. No. So your collection letters right now, you want to follow your policy, and your policy should say that you send one via certified mail, that it's usually the payment plan notice is the one that you're going to see on there, but it should say 18 months for your certified mail. And then it says, and contact the owner via two other methods. So two of the three, and the three are text message, email, or telephone number. This bill, once it goes into effect, still leaves that requirement in there. The only difference is that it says if you happen to not have email and telephone, then in addition to the certified letter, you can send it via regular mail. Assuming you have a current email address, right? Licensing updates. That one did not come up this year for community managers or management companies, which is what we saw last year. I don't know if it's going to rear its head again, probably. I do think the alternative dispute resolution bill, which would have had many different revisions to it, but started out as like a mandatory arbitration mediation for associations for everything, including collection enforcement. I think we're going to probably see that one come up again. We will likely see manager licensing come up again. I think we're going to see a little more with insurance. I'd be surprised if we didn't see construction defect again because of the bills that came through this year, but we'll see. The session will go back in and we'll do our best to report and go from there. Are HOA members allowed to get copies of the insurance that the HOA has for things? So HOA members, you're going to want to follow the association's inspection of records policy, and that will tell you what records you're entitled to request from the association. And then do HOAs automatically send out updated policies and procedures to all members, or does it have to be requested? There's a certain amount of documentation the association is required to send out every year, but anything past that, look at that inspection of records policy, because it's going to tell you exactly what else you are entitled to request and that your association has to provide to you. One of the questions on this is with regarding to the two methods of contact for collection. Two of the three, it says if we call the owner, do we need to read the entire letter to them? And that actually has been debated. Different law firms have different viewpoints. I can tell you that our law firm strictly follows that legislative bill. And so our answer is that, yes, you need to tell them exactly what's in the letter. There are other places that have said you just need to let them know where to access that information. We haven't had a court come down on that either way, at least not to my knowledge. So I don't know how a court would decide. All right, so we're at 12:59. Oh, one more question. The BOR filing. So the filing, the beneficial ownership report. So remember, this was required as of January 1 of this year. Then it was on again, off again, on again, off again. We all got whiplash. It is not required for domestic companies right now. So I say right now because who knows, but at least FinCEN has pulled that requirement. It only now applies to foreign companies. So you do not need to continue reporting on the beneficial ownership interest requirements, the BOI report. All right. It is 12:59. Yes, you can text as an option for contact if you have their email. let us know if you have any more questions. Contact your attorney, get your collection policy in place, guys. Otherwise, you're going to end up with like all of this delinquent assessments that you can't collect on until you get the policy, and assessments are how you fund the association, right? Okay, have a great day. Thanks for letting me join you for the hour, and we'll talk again soon. Bye.